Okay.
All right, well, good morning, everyone. I thought we'd have a little fun today. Today we're going to talk about, as my brilliant illustration demonstrates, one of my favorite subjects, patent trolls. And I say it's one of my favorite subjects because a lot of the people that we represent or end up advising, in many ways, uh, we end up involved because they're the victims of patent trolls. And patent trolls are ubiquitous, or patent trolling is ubiquitous. In fact, some of the significant portion of the endowments of some very famous technical universities have been built on the revenues obtained through patent trolling. I think maybe the best thing I can do to start off is by defining exactly what a patent troll is, so that when you run into one, and you will run into one at some point in your careers, so that you know what they are. Basically, a patent troll is a person or a company that obtains the rights to a patent, one or more patents, in order to profit by means of either licensing or litigating in some way the rights under that patent. And as my little picture implies, it's a pejorative term generally, because in most cases it describes a person or a company that attempts to enforce patent rights against accused of infringers, people like you or my clients, far beyond the patent's claims and far beyond what the patent actually protects, in order to basically extort a penalty, a fee, or some other settlement from the alleged infringer. And there used to be a cigarette commercial. I don't remember the brand, but it's certainly before all of your times. But the motto was, "I'd rather fight than switch." And a lot of entrepreneurs find themselves in the position of having to kind of go by that mantra, which is, rather than fight, rather than incur the costs of litigating against a patent troll, it's easier to just pay them off. So I want to talk to you a little bit about today about how to handle a patent troll, what they try to do, and what you can do to defend yourself against them. The first thing you have to understand is that most patent trolls create shell corporations in order to insulate themselves from liability. And then what they do is they file or obtain vague patents. And when I talk about a vague patent, what I'm talking about is a patent that whose claims are vague or overbroad or overstated, such that the technology that they describe is really hard to define. Remember, we talked about the importance of every word in the claims section. And that goes doubly for patent trolls, because when it comes to patent trolls, the broader or the more vague the description of the technology is in the claims section, the more opportunity they will have to extort money from alleged infringers. And so there's a large number of patent trolls in the country, and some of them take the form of large companies. There's one that has come up more than once in my business, which has acquired a large number of patents, usually by buying patents up at auctions for bankrupt companies. So if a small startup doesn't succeed and it owns a certain number of patents that they had hoped to prosecute commercially. And for one reason or another, the business fails, they go into bankruptcy. These patent troll companies swoop in and for pennies on the dollar, pick up the rights to various patents that were owned by, in some cases, the inventors themselves who tried to commercialize them by beginning a startup. And they collect hundreds and hundreds of patents in a portfolio. And then rather than practice the patents, what they do is they go out and send extortion letters, just like this one right here that was received by one of my clients recently. I'll get into what to do about that in a little while. I want to talk a little bit more about these companies and the harm that they cause to the world of intellectual property. There's a lot of these companies in the United States, but more recently they've been establishing themselves outside of the country in places like China or more likely in Canada, in order to avoid the jurisdiction as best they can of our courts. So they're kind of, a lot of them are also offshore companies established in the Cayman Islands and other places like that. And the reason for that is strategic, because when they establish themselves, as I said, it's usually a shell company that has no assets. And through various layering, they are able to hide the identity of the true patent trolls. So if you or I wanted to start a patent troll company, the first thing we might do is choose a good jurisdiction like the Cayman Islands or Canada, or at least in the United States, it used to be Texas. But we'll talk about how that's not the case anymore. And we'd create a shell company, usually an LLC. And then what we would do is we would have that shell company owned by a series of other shell companies. And under state or the law of the jurisdiction that we chose, set it up so that we don't have to disclose who we are. If you are to form a corporation here in Massachusetts, you have to file articles of organization. And on the articles of organization, you have to identify the directors and the shareholders and all the officers of the corporation. You have to identify the incorporators. And so that if your company gets sued, they know who to go to in order to, they know who to hold responsible. Well, what patent trolls do is they choose a jurisdiction that where you can create a series of shell corporations that hide your identity. That way, when you get countersued, there's nothing for the alleged infringer who's been unfairly accused to get. So that's the first thing they do. They choose a jurisdiction that is favorable, and then they create an entity that they can essentially hide behind. As a matter of fact, just to give you some numbers, in the last year where there are numbers available, nearly 75% of all litigation involving intellectual property involved patent trolling. So when you think of it, of the thousands of cases that are filed every year, and in the last year that numbers were available, there were 3,440 patent infringement lawsuits filed in the United States against small companies. 3,440. And of that, 75% were simply by NPEs, non-practicing entities, who aren't really practicing the technology. They're just enforcing the rights through these trolling operations. And that is up significantly. Back in the early 2000, to 2005 range, the number of patent troll lawsuits was in the hundreds. And nowadays, it's literally in the thousands. But I'm hoping to see a change in that trend because of some new tools that have been given to people that are accused of infringement, some of which have been given to us by Congress, and some unexpectedly by our very conservative Supreme Court. So, but the problem with this litigation is it's enormously expensive. So when you get one of these cease and desist letters from one of these trolling companies, you have a decision to make. You know, do we fight them or do we give in? And that is often an economic decision. To respond to one of these letters and litigate it, you know, if there's a controversy, is going to cost a small company anywhere between $60,000 and $100,000. And if you actually get into litigation where you have to try a patent infringement case, it can cost anywhere from $100,000 to $500,000. And if the technology is very valuable, that is technology that's worth over $10 million, the average price of defending one of those cases is $2 or $3 million. So you can see that this can really have an impact on the decision that a small business or even a large business makes when it comes to patent trolls. Obviously, and there's a sliding scale. So the more valuable the technology, the more expensive usually it is to litigate. In fact, there have been some studies. There was a study in 2005 that where trolls sued approximately 800 small companies, which is less than 100. A small company being a company with less than $100 million in value. And that these lawsuits actually resulted in a reduction in research and development. So when small companies, startups that do a lot of the R&D in the country, get hit with these litigation costs, they have to make a decision. Oftentimes they fight because their lifeblood is tied to the patent. But when they have to pay law firms to defend these cases, they have to take the money away from some other area, and usually that's research and development. There have been a number of studies out of the Harvard Business School and the University of Texas, which showed that firms who were forced to defend trolling lawsuits usually ended up reducing R&D by anywhere from 20 to 80%, and that's a significant problem because, as we talked about a couple of weeks ago, the whole world of intellectual property is set up in order to assure that knowledge is disseminated and that technology advances. And patent troll lawsuits are a very, very big impediment to the dissemination of knowledge and the development of technology. Catherine Tucker at MIT, I think she's at the Sloan School, studied joint venture capital investment and found that in a study that she did and published, I think in 2014, that about 15% of investment capital was reduced, that is, was available to invest in small firms because of patent troll litigation. So it has a real effect on startups and on research and development and the dissemination of information and technology. Now, what's the cause of patent trolling? How is it that they're able to exploit these entrepreneurs? Well, the main problem is in the United States Patent and Trademark Office. the problem with the United States Patent and Trademark Office is there's no uniformity when it comes to the approval of patent applications. You may file a patent application for a particular technology. I can file a patent application for a very similar technology, and we can have very different results. Your application may be rejected while my application is accepted. And it really, what it comes down to is careless claims examiner. When we talked about filing a patent application, I talked to you about how much of a patent application involves a dialogue between you and the claims examiner. There's a negotiation, in fact, a haggling that goes on over the terms of a patent application. If you have a good, conservative patent examiner, you may find yourself in a real fight to get every word that you want in the claims section approved, whereas other patent examiners, sort of let anything go. And it's the ones that let anything go that cause the problems, because they issue patents that are really broad, that are really vague, and for technologies, quite frankly, that are very questionable. And in case you think that this is only a problem for small entrepreneurs, think again, because Apple leads the world in being sued by patent trolls. Last year alone, I think Apple was a defendant in over 120 lawsuits brought by patent trolls. I think in second place is Hewlett Packard, in third place is Microsoft, and fourth place, I think, is AT&T. They make up the majority of patent troll litigation, actually, or at least they make up the 30% that does not involve small businesses. And obviously they make up all of the really big, expensive cases. So it's a problem for small businesses and big businesses alike. So as I said, the heart of a patent is its claims section. And if you get a careless claims examiner who issues a patent that is broad and vague, then that's the kind of thing that patent trolls like to snap up. And what they'll do is they will literally go on the USPTO website and they'll examine the patents that have been issued, and they will try to find one where the language is vague and they think can be exploited, and that's what they'll do. Well, I'll give you an example. We talked about the Broad case involving the CRISPR technology. Well, when that technology when that patent application was made, the attorneys for the University of California, the originators of the CRISPR technology, were doing their clients' bidding when they tried to ram through the USPTO a very broad set of claims that describe the technology in very vague terms so that it could cover as much intellectual property as possible. But as we found out, when the Broad came along and were accused by the owners of the technology of infringement, the Broad was able to show that the USPTO issued a much broader patent than the inventor was entitled to, because they had not demonstrated the technology across all species. But that litigation cost millions, literally millions. There was nothing the Broad could do, since it had developed the technology that they thought that they had proprietary interest in. There's nothing the Broad could do except file a cancellation action in the USPTO and litigate it in the federal courts. Of course, the more valuable the technology is, the more likely it is that you're going to be litigating it in court. technology that isn't valuable doesn't get litigated. But that's an example of where a patent examiner issued a patent that was too broad, and it caused all kinds of trouble. If the examiner had limited the patent to only the technology that the inventor had been able to demonstrate, there'd have been no litigation. And law firms like mine and the ones that represented the Broad Institute would have to find something else to do, because there wouldn't be any litigation, there wouldn't be any dispute. So the problem with trolling really begins and ends at the doorstep of the United States Patent and Trademark Office. And that's something that you need to take into consideration when filing your patent application. You know, do you really want to have a very broad claim in your patent application? Or do you want to limit it strictly to the technology that you've been able to demonstrate, no matter what the claims examiner will let you do? And that usually depends upon what your object is. If your object is to practice the technology, limiting it to what you can demonstrate is probably perfectly acceptable and a good business decision. But if you're a patent troll, a non-practicing entity, what you want to do, your object is to use the technology as a lever against innocent practitioners, and so you want as broad a technology description in your claims as you can get. The trouble with the USPTO is they don't know whether the application is being filed by a patent troll or by the original inventor. They're not allowed to ask that. And so there's no way of screening applications at the USPTO that have been filed by patent trolls or by inventors. They have to go by what's on the application itself. So since there's no bar at the door, no way of screening trolls from inventors at the application stage, the only way that we can do that is sort of screen ourselves. And I always advise my clients when they're filing an application to limit the claims to what they're able to demonstrate. Since all of them are intending to practice the technology and are not, I don't represent non-practicing entities. So I would always, in an effort to avoid litigation and misunderstandings down the line, try to get my clients to restrict the application to the technology that they're able to demonstrate. All right, and that's something I think that you should take into consideration, especially if you're not a non-practicing entities and you're looking to practice the technology that you patent. I'll give you some examples of stuff that people have been sued for, and I'm not making this up. There's literally federal cases involved in this. People have been sued for using the Google Play Store. People have been sued for using scanners. People have been sued for using Wi-Fi. People have been sued for actually using Microsoft. And they've been sued by patent trolls who have tried to make the case that the technology that they were using or that they had patented was somehow covered by the Google Play Store, by scanners or some other device. Now they lost all of those cases, but the companies that got sued for using it ended up having to pay a lot of money in order to defend themselves from those kinds of cases. And the companies, like I said, there are big companies out there. Some of the names of the companies, there's one out there that wrote this letter here called Unilock. They're a big trolling company in the United States. And there's another one which is infamous called Marathon Patent Group, which really is probably the biggest, the baddest, and the worst patent troll group out there. All of them, though, created shell corporations. In those particular cases, they're incorporated in Texas, which used to have some very liberal laws. The East Texas became patent troll central for about 2 decades until some recent decisions of the Supreme Court Because what companies would do is they would incorporate in Texas, and then they'd sue an entrepreneur out here in Massachusetts. And as you can imagine, if you have to defend yourself in a case that was brought in Texas, that's a much more expensive proposition, not to mention not exactly a home field advantage for someone from Massachusetts that works to the advantage of patent trolls. And in fact, in case after case that we've done, we did a case involving Marathon Patent Group for a company in Massachusetts that was forced, unfortunately, by the United States District Court, because that was the state of the law at the time, to defend the infringement case in Utah. They had no place of business in Utah. They had no contacts with Utah. They were incorporated in Massachusetts, but because the troll company had a place of business in Utah, they sued my client out there, and we were forced to defend it there. We ultimately won the case, but it cost my client a significant amount of money.
Steve?
Yeah.
Can I just say something about that East Texas situation?
Sure. I wish
because I both worked for and against the big law firm there in the particular city in Texas, and I also testified in that city. But they also had the judges in their hip pocket.
Absolutely.
They were working hand in hand, and it was a travesty of the justice system.
Some of the judges out there had an interest in the patent troll firms whose cases they were presiding over. You believe that?
I believe it because I didn't see that, but I saw the behavior of the attorneys and the judges. It was right out of a third world country, except we don't usually consider ourselves a third world country, but maybe that's Texas. I don't know.
That is Texas. As someone that's had to go out there and litigate cases, I can tell you that is Texas. But along came the Supreme Court in 2017. And they decided in a case called Heartland versus Kraft Foods. You've all heard of Kraft Foods. Well, Heartland was the patent troll company. And they sued Kraft Foods out in Texas. Of course, Kraft Foods had the wherewithal to take them on. And ultimately, what the Supreme Court did in that case, which was an enormous blow to patent trolls, especially those located in East Texas, is that they decided to depart from the rule at that time that whether or not you had a place of business, you had to defend in the jurisdiction where you're sued. In other words, where the patent troll is located. The Supreme Court said that, and they went back to cases that were decided in the 1600s, and that's before the Supreme Court was established. But they went back to really basic principles, some of the basic principles that we talked about in the beginning of this course, and they decided that a company does not need to defend in the jurisdiction. And in fact, in order to sue a company for infringement, that company must be incorporated or have a usual place of business in the state where they're sued. So all of those cases in Utah and in Texas and in other jurisdictions where the patent trolls had a home field advantage have now been done away with, because under the Heartland versus Kraft decision, if you can't be sued except in the place where you're doing business or where you're incorporated. And that was a big blow to patent trolls. Another big blow to patent trolls came in another Supreme Court decision that same year called Impression Products versus Lexmark. As anybody who has ever had paper copier jam on them knows. When you pull out the drawer, there are trays of paper and also somewhere in the machine, toner cartridges. And I don't know if you know about this, but if you've ever purchased a copy machine, really copy machines are fungible. One day, I believe that we will be able to literally walk from one city to another on the top of copy machines without ever touching the ground, because so many are produced, but at the end of their leases are simply disposed of by the leasing companies that own them. And that's because the real money in copiers comes in the sale of toner and the maintenance of the machines. And when I say the sale of toner is the real moneymaker when it comes to copiers, I have Lexmark Industries in mind. As anybody who's ever bought toner at Staples or anyplace else, that's expensive stuff usually. But the technology is really cheap. The only reason that it's expensive is because Lexmark owns the patent on the toner cartridge technology. And Lexmark does an awful lot of litigation in order to protect their technology. But one of the things that they did when they weren't able to, when they weren't successful, when others would come up with toner cartridges, for instance, that used a different technology, is they tried to control the secondary market for these things by trolling litigation. What many companies do, and in fact there are companies that do nothing but this, they take old cartridges, fill them with new toner, and sell them on a secondary market. And so what Lexmark did is they started suing these companies, and in order to not only control their technology, but control the secondary market. So the technology would be sold as part of the copy machine. And then when the cartridges were disposed of or sent to a secondary company to recycle and reuse, Lexmark wanted to stop that. And so they sued the secondary makers. Impression Products was the one that was recycling these toner cartridges. And while the details of the case are not important, the general proposition that was changed by this case is important when it comes to patent trolling, because what the Supreme Court did in that case is they struck another blow to patent trolls, which was that they held that, and again, they went back to really ancient principles of intellectual property law that we talked about in our first two lectures, which basically said, and they basically held that once a product is placed in commerce, all of the rights of the patent holder disappear. So when you build that invention and you commercialize it and you sell it, in this case, a toner cartridge, your right to control that technology ends at the point of sale. And so Lexmark was not allowed to enforce their intellectual properties rights on the secondary market. And that, again, eliminated another very large group of patent troll cases, because if the technology rights end when you exchange money for the technology, when you buy the invention, if you own the rights to a mousetrap and I buy the mousetrap from you, I can do anything I want with that mousetrap. I can modify it, I can sell it, I can use it, I can practice it. The exchange of money ends your intellectual property rights and gives me the right to do anything I want with your technology. And so, as I said, I can practice it. I can change it in any way I want. I can resell it if I want, as is, without violating your intellectual property rights. And for patent trolls, that was another another stab at the heart of what their trolling litigation is based on. Congress passed a law in 2013, and in fact, President Obama directed the United States Patent and Trademark Office to be much more strict when it came to approving patents and to require the inventors and the applicants to define their claims very specifically. So between the Supreme Court and the directives given to the USPTO and some new laws that have been passed by Congress, one of which is named the Patent Integrity Litigation Act, which provided for trolls to get hit with costs and multiple attorney's fees and even punitive damages if they lost a patent troll case. Massachusetts has a consumer protection statute that protects you as an entrepreneur against patent trolls. And in fact, that's one of the things that we used when we were responding to this patent troll cease and desist letter for our client. And we obtained multiple damages for our client. It took years. It was very expensive initially for them, but they got their money back. They kept their technology, and we were able to hit the patent troll company with a judgment for multiple damages that included attorney's fees and other things that the Consumer Protection Statute in Massachusetts provides. So we went from a problem that was really acute in this country about 5 years ago to one that is slowly but surely coming under control because of consumer protection statutes, congressional acts that allow patent trolls to be responsible for damages in the event they lose, stricter measures at the United States Patent and Trademark Office, and lo and behold, even the Supreme Court has gotten in on the act. And by the way, they're really loath to get involved in intellectual property litigation. So those two, the Heartland and the Impression Products cases, were really a big departure for the Supreme Court, but taken together, all of those things have been very useful in cutting back trolling litigation, and now at least gives our clients something that they can use when they're confronted with one of these cease and desist letters. Any questions on what I've gone over so far? Okay, cool. So I'm going to tell you what to do, since I'm all about practical advice, what to do when you get one of these letters. And I can almost assure you that you're going to get one of these letters. That's how ubiquitous patent trolling is. And by the way, copyright trolling, it's the same thing. There are companies like Pro Rights is one of the companies that use that software I talked to you about, that Wayback software. Do you know what I'm talking about by Wayback software? Actually, we use it here in the office quite often. We used it the other day in a case where we had brought suit against a healthcare provider that had made certain promises, representations, and warranties about the services that they would provide to a client, and then failed to deliver. And they denied that they had made any of these representations and warranties. So that left my client in a position of having it was going to be their word against the defendant's word. But what we did is we used this Wayback software to look up the websites of this provider back in, it was October of 2016, 2017, and 2018. Websites that the defendant had said that they had taken down, and they had no information on what might have been contained on those. Well, as I think I've said before, nothing that you put on the internet ever disappears. It just doesn't. So if you post something on Facebook, if you post something on Instagram, if you post anything on any internet platform, as sure as I'm standing here, no matter what you do, there's nothing you can do to erase it. All right. And so what we did is we went back using this technology. It's called Wayback, and we were able to get screenshots of the providers' websites from, how many years ago? 9, 10 years ago. And there they were. All the promises were in black and white. So the promises that the defendant said that they never made and denied existed were right there for us to download. Well, internet trolls use the same technology. What they do is they will secure a client like AP or UPI, somebody that does photographs and posts photographs. And what they will do is they will take the photograph, and the software allows you to image the intellectual property, and it will search the internet. You press enter, and eventually what happens is it scans the entire internet, everything that's ever been posted, and it gives you the people or the IP addresses of everyone that's ever posted that particular picture, that photograph. And then what the companies do is they just look to see whether or not there was a licensing agreement between the IP address holder and their client. And if they don't find a license, and 99.9% of the time they don't find a license, then they send them a nasty letter, a threatening letter, telling them that they're going to be sued. Oftentimes they use stationery from fake law firms. And so whether it happens to be a copyright of a photograph, a copyright of a music product, or a patent that you've been granted or that has been issued by the US PTO, what the companies use is software to search the internet for evidence that this technology has been used. And then they send out these troll letters. Now, there are lots of reasons why you can post this stuff on the internet. Now, we've talked about them: fair use, political commentary. If you change the image in any way, it's not subject to copyright protection. So if you post, for instance, an AP photograph that's just a thumbnail that's been cropped in any way, that use may very well be proper. But the companies that send you these nasty letters don't tell you that. What they try to do is they try to scare you into sending them $5,000 or $2,500 or $1,500, or eventually, as we've done in some cases, got them down from $10,000 to $100 if they promise to go away. So what should you do when you get one of these letters? Because there are so many scams out there, you can't be sure when you get one of these letters whether it's legitimate or if it's not. A company like Pro Rights actually does have legitimate clients. It doesn't mean that their methods are legitimate, but they do actually represent companies like AP and UPI. They also represent music companies. And while I say the techniques are not legitimate, oftentimes they do represent a real client, and there's a real issue involving an infringement. And so the first thing you should do when you get one of these nasty letters is don't ignore it, okay? It's very important that you at least treat it seriously, not necessarily by responding, but by giving it to somebody that knows what they're doing, and that means an IP lawyer. And then the IP lawyer will take a look at it and determine whether or not, first of all, it's a scam. And by the way, you may be able to tell some of these are scam, because if you just Google internet scams, sometimes the companies are listed right there. But let's assume that, that it's a legitimate company, that it's not a pure scam from somebody in the Ukraine. They actually represent a company that has rights to a picture that you may have unwittingly put on the internet at some point in the last 10 years. So what do? Well, you don't ignore that letter, and you bring it to somebody that knows what they're doing and have them take a look at it. And you want to do that because nowhere in these letters do they ever talk to you about the rights that you have. As I said, fair use may be a defense. There may be defenses that you can raise where you've changed the image. There's all kinds of defenses to these things. And so the first thing you want to do, rather than fork over money to any of these companies, is have a professional take a look at it. And then they'll evaluate whether or not it's a strong case of infringement or a weak case of infringement. And sometimes what needs to happen is there needs to be an email back from you, or it may take a strongly worded letter from a law firm pointing out that the claim is invalid. Or in some cases, it may actually pay to pay a small amount of ransom just to get them off your back, because you may have unwittingly infringed on somebody's patent. And then it becomes a matter of whether or not it's worth what they say it is in the letter. I can tell you that every time you get a letter like one of these, they're never going to tell you the true value of the intellectual property that you may have infringed on. It's usually a tenth or a hundredth of the value that they've actually that they actually quote to you. So, a photo from AP may be worth $100, but the letter will say it's worth 25,000. So usually, what happens, even in the cases where you've actually unwittingly infringed on the technology, there's ways out of it. But the most important thing is to not ignore these letters. And if you determine that they're legitimate, you need to hand them over to a professional who will evaluate the strengths and weaknesses of your case and recommend an appropriate course of action. Some of these companies are just looking for low-hanging fruit, and other companies, that is, they'll take whatever they can get. And other companies are more serious, and usually the more expensive the technology, the more serious they are about them. So that's what you do if you get one of these letters from one of these little guys here. That's all I've got for you today. Next week, we're going to be talking about the CRISPR decision, because I think it really points out an awful lot of the concepts that we've talked about in this class, things that I think the case illustrates, demonstrates all of the principles that we've been talking about. It's kind of a good way of wrapping what we've been talking about up in a neat package. And it gives you, I think, a perspective as an entrepreneur of what intellectual property rights mean and what needs to be done to enforce them or defend yourself from a claim of infringement. So we'll be talking about the Broad decision next week, which is one of my favorite cases. Any questions? Okay, I actually did bring some patents to show you. Some of the crazy patents that trolls have gotten involve a cat exerciser, a swing hung from a branch of a tree. The Patent and Trademark Office has actually issued patents for such things. So beware of patent trolls, because the USPTO isn't there to protect you sometimes, and you need to protect yourself. Okay, I think that's all I got. We're right on time.